Welcome, everybody. Thank you so much for joining Tara and I this evening. What we're going to do tonight, something a little different than what we have because we haven't had an opportunity yet. But we are going to start back at the beginning of how we got from point A to point B. And we're going to discuss a whole lot of the court documents, things like that. So we're going to go over the custody documents. We're also going to go over the probable cause statements that came out today and what we learned from that. So I really appreciate you guys being here. And hi, Scott H. Thank you. Thank you very much to our mods. We just ask that any, real talk of the children, of course, they're going to be a little bit of it. It's by their initials only. But any other kind of talk of the children or that situation, we just want to eliminate that a little bit if we can. And then just be kind to each other. That's really all we ask. Be respectful and be kind to each other. So with that, let's get started.
Let's do it.
All right. So just a little bit of history on them. Veronica and Wrangler dated throughout high school. So they've known each other for quite some time. They were never married. They had their first child together, a son, on December 18th, 2015. And they had their daughter April 2nd of 2018. Now, from day one, they both worked together co-parenting. But on February 26, 2021, Wrangler filed for joint custody of the children. And that's this document that's right here on the screen. However, Veronica was granted custody with Wrangler getting visitation, standard visitation rights. And then despite that order, they just continued to work together and they basically, they shared custody of both of the children and they alternated that weekly, but it wasn't an actual court order. Then we get to June 2nd of 2020 and Wrangler filed an amended petition, again, asking the court to reverse the original decision that granted Veronica the custody. And he wanted to be awarded primary physical custody at the time, with Veronica just receiving visitation only. The judge that was the original judge on the first case, Judge Christina Larson, she denied it on his second, when he tried to appeal it here on June 2nd, 2020. And that's what's showing right here. Judge Larson took the time to review her trial notes and again ruled that the mother should have primary custody and the father should have a standard visitation schedule. And it's also important to note that Judge Larson has been under 24/7 protection since the latest went missing. And so I do have those documents. Let me get those pulled up here where you guys can see them, hopefully. So there's going to be quite a bit of reading, but I read fairly fast. So hopefully we don't have to take forever on it. Let me get that.
So we're going through the custody because it is important to the case as it's listed in the affidavit. So this is why we need to kind of walk back and take a look at what led up to the events that brought us all together.
Yes. All right. So this one is one of the very first custody documents I was able to really find. Remember that they did seal all these. I was able to get quite a bit before they were sealed. There's really only one that I didn't, but we have most of them. So this was about, he being awarded the custody. The district court in this case decided which of two young unmarried parents should have primary custody of the party's young children and the visitation that would be awarded the non-custodial parent. The district court awarded custody to the defendant, Veronica, despite undisputed evidence that she had filed numerous unsubstantiated neglect and abuse charges against Wrangler. Now, keep in mind, this is what Wrangler's claiming in the documents. She requested unnecessary law enforcement standbys for visitation exchanges. She attempted to thwart Wrangler's relationship with the children by relocating multiple times without notice to Wrangler. Her employment history demonstrated her to be unreliable and irresponsible. And when she was working, her schedule required that the children be looked after by third party caregivers. And there was undisputed evidence of neglect of the children, resulting in physical harm to them while in her physical custody. In contrast, Wrangler, who was denied his request for primary custody, according to undisputed evidence, actively worked to try to effectively co parent with Veronica, had matured into a responsible father who provided excellent care for and supervision of the children, and held a steady job with flexible hours that allowed him to maximize his time with the children. Wrangler had also enjoyed 50% physical custody of his children, pursuant to an agreed temporary order since the summer of 2019. The district court's orders of custody and visitation are clearly against the weight of the evidence and an abuse of discretion. Wrangler requests this court reverse the district court's award of custody to Veronica and remand this case with instructions to the district court to enter an order granting Wrangler primary custody of the minor children with visitation for Veronica. Let me just see. Is there like any comments I need to, if you need me to stop, Tara, just let me know.
So far, so good. We just have somebody saying they were happy they were referred over to this coverage. So keep going. We're good.
Wonderful. Okay. I can't see any of the chat while I'm reading this, so just holler
You're
if I
good.
need
I'm
to
watching it.
address. Okay. The party's son was born December 18th, 2015, and their daughter born April 2nd, 2018. Wrangler and Veronica were never married. On February 27th, 2019, Wrangler filed his petition for paternity, custody, and visitation and application for temporary orders, seeking a judicial determination of his paternity of the children, joint custody with Veronica as the primary custodian, and scheduled visitation for himself. On May 7, 2019, the district court entered temporary orders granting custody to Veronica and visitation to Wrangler. However, in the early summer of 2019, the parties agreed, despite the temporary order, to share physical custody of the minor children, alternating weekly. Their agreement was later memorialized in an order of the court. Later in the summer, Veronica moved to Colorado without court approval and without notice to Wrangler. In her court filings, Veronica made no attempt to deny that she had moved to Colorado with the children without any notice to Wrangler. By the time of the trial, though, she had changed her story and claimed to have consulted Wrangler regarding the move. Wrangler was consistent in his court filings and his testimony that she had not done so. Since the filing of the petition, Veronica relocated with the children 4 times in just a few months, moving them from Oklahoma to Kansas, Kansas back to Oklahoma, then Oklahoma to Colorado, then Colorado back to Kansas. When Wrangler would receive his alternating custody with the children, they always arrived hungry. They were bedwetting and they did not want to return to Veronica's custody. And another reminder, this is just what Wrangler's claiming, okay? This isn't what a judge said. Wrangler filed an amended petition on June 2nd, 2020, wherein he asked the court to award primary physical custody of the children to him instead of Veronica, citing Veronica's behavior over the course of a year. Wrangler's amended petition cited Veronica's conduct in relocating the children multiple times, failing to abide by and follow the orders of the court, efforts to program the children against Wrangler and make them believe he was dangerous, filing false charges against Wrangler concerning one of the children with the Oklahoma Department of Human Services, and previously with authorities in the state of Kansas, and failing to consult with Wrangler on important decisions involving the children's best interests as the ground supporting his change of position with respect to seeking primary custody of the children. The case was tried January 29, 2021 and February 26, 2021. Wrangler presented, in addition to himself, multiple witnesses who supported his versions of events and his request for custody. Additionally, Veronica admitted under oath many of the facts that supported Wrangler's request for custody. Wrangler's first witness was Ilana Cloud, a child protective service worker with the Oklahoma Department of Human Services. Ms. Cloud testified to 3 referrals made to DHS in 2019 to 2020 against Wrangler, involving accusations of neglect, abuse, or harm to one of the children. The findings by DHS in each and every one of the referrals was that the allegations were unsubstantiated. Additionally, Ms. Cloud testified DHS reports reflected there was no evidence of bruising or other marks on the child to support the accusations. On cross-examination, she testified that when she asked the child what choking meant, he said his mom, Veronica, had told him to say it. As reflected in Plaintiff's Exhibit 15 and by her own admission, Veronica was responsible for at least 5 of the reports to DHS or to Kansas authorities accusing Wrangler of abusing the child. None of the reports of the investigations reflect any corroborating witnesses who could substantiate Veronica's accusations. Veronica also admitted she had not provided any photographs, even though she claimed to have some of the alleged bruising on the child's neck. Ms. Cloud testified one DHS report reflected the investigator witnessed the child come running into the house, excited to see his dad, throwing himself on his dad, hugging him, and telling him he missed him and loved him. The worker found, quote unquote, everything appeared to be appropriate with the father and the children. Wrangler's next witness, this one's a little interesting for me, but Wrangler's next witness was the sheriff of Cimarron County, Oklahoma, Sheriff Michael Bergutsky. Sheriff Bergutsky testified Veronica made several allegations of neglect or abuse of the children by Wrangler and made requests for civil standbys during custodial exchanges. But, quote unquote, there were never any substantiated claims based on those requests. In fact, matters reached the point where the sheriff informed Veronica that his office would no longer supervise the visitation exchanges. That's been a question a lot in the group, too. So there's the answer of why they weren't doing that. The sheriff never saw anything in the visitation exchanges that caused him concern about Wrangler's treatment. Veronica's bogus accusations of abuse, the sheriff found no evidence to corroborate her claims. Although Veronica claimed she had photographic evidence, she provided none to the sheriff, and he saw no evidence on the children of any trauma. Wrangler's next witness was a rancher neighbor, Larry Sauls. Mr. Sauls keeps some cattle on Wrangler's place and thus goes over there daily to care for his cattle. He witnessed Wrangler taking care of the children when they were in Wrangler's custody. He had opportunities to witness Wrangler's interactions with the children in Wrangler's home. He testified the home was clean and well kept with food in the cabinets. The children never appeared to be fearful of Wrangler, nor did Mr. Sauls observe anything in Wrangler's interaction with the children that gave him cause for concern that they might be being abused or neglected by Wrangler. In fact, he testified, Wrangler's a good father. He's always with his kids, and I call Cole Colt 45. Him and his sister, they feed cake to my cows there by the fence. And Wrangler's always there. I mean, they're not out by themselves. I haven't seen any of that. He's always watching them. When called in Wrangler's case in chief, Veronica admitted much of the evidence against her that demonstrated it was not in the best interest of the children for her to remain the primary custodian. For example, she admitted that she had agreed to shared custody and that despite having made all the referrals to DHS alleging Wrangler was abusing one of the children, she never sought any emergency orders. She admitted that in addition to the referrals to DHS in Oklahoma, she made 2 reports to Kansas authorities, and those reports were likewise unsubstantiated. She also admitted to moving with the children back and forth between Oklahoma, Kansas, and Colorado until the court told her that she needed to pick a place to live. She admitted that after she and Wrangler broke up for good in about December of 2018, she would not let him see either of his children for a period, and that she objected to the one child having his father, Wrangler's, last name. She admitted that she had agreed to allow the child to participate in a school Christmas program during her week for custody. But then, at the last minute, Knowing that Wrangler and his family would have been planning to attend the program, she told Wrangler that the child was not going to participate because the 4-year-old didn't want to go. Veronica admitted her fiance had moved in and out of her house, despite supposedly being engaged to him, and the fact that she admitted he was around the children a lot and had the opportunity to observe her with the children. She did not call him as a witness to testify in her case. Veronica admitted to her erratic work history that demonstrated she was irresponsible and unreliable. She admitted she has changed jobs a lot. She was terminated from one job for not showing up for work. Her work records for her brief job in Colorado reflected, quote unquote, was evicted, then moved to Hugoton, Kansas, without a working vehicle and never made it back to Springfield to finish out the schedule. The records from another company where Veronica was employed for just 2 months reflected, quote unquote, no call, no show on too many shifts and too many call ins, not dependable. For a 4-month period, she held a job at a gas station convenience store, but she walked off the job when they would not accommodate her every request for time off or schedule changes. Records from that employer indicated they would not rehire her. Wrangler and Veronica disagree over the school the children should attend, with Wrangler wanting them to attend Yarborough School in Oklahoma and Veronica wanting them to attend school in Hugoton, Kansas. Despite living in Hugoton and wanting the children to attend school there, Veronica had not applied for a job in healthcare, her field, in Hugoton. She also admitted to not working in Elkhart, Kansas, which is on the Oklahoma border and only a little over 9 miles from the Yarborough School, so as to intentionally mislead the court regarding the convenience of the Yarborough School. Additionally, her choice to avoid working in Elkhart and to work elsewhere meant she often had to leave for work at 4:30 a.m. Veronica admitted at trial that she leaves the children with Wrangler's paternal grandmother, Debbie Davis, whose turkeys have pecked 2-year-old child, leaving marks on her more than once. In Ms. Davis' own testimony, she not only admitted that her turkeys pecked both children, but more horrifyingly, that she has made it the quote unquote chore every morning for the little girl, a little 2-year-old girl, to go out and feed and water the very turkeys who peck her. Veronica also admitted to an incident when the son was bitten on the face by a dog severely enough to puncture the skin, and she, Veronica, did not seek any medical treatment for him, did not verify whether the dog had its shots, and did not tell Wrangler about the incident. Tad Cullum, a local farmer, Wrangler's mother's boyfriend and Wrangler's employer, also testified for Wrangler. Mr. Cullum testified he had no problems with Wrangler with respect to his work ethic or any substance abuse. Prior to working for Mr. Cullum, Wrangler had worked as a cook at a truck stop in Elkhart, but working for Mr. Cullum gave him a more flexible schedule to allow him to be available for his children. Mr. Cullum observed Wrangler around the children and testified he absolutely never saw anything that would indicate they were neglected or abused when in Wrangler's care. There was no indication the children feared Wrangler, and Wrangler kept the house clean, dishes done, clothes washed, etc. when caring for the children. Mr. Cullum also observed Wrangler making an effort to co-parent with Veronica. How are we doing in there, Tara?
So far, so good. They seem to be hanging on to every word because
Okay.
nobody's asking questions.
Okay.
You're good.
Okay, cool. Wrangler's mother, Tiffany Adams, corroborated Wrangler's claims that when he initially filed his petition, Veronica was not allowing Wrangler to see either of his children. Wrangler had been providing financial support to the children. Veronica never notified Wrangler of any of her multiple relocations while the case was pending, including her move to Colorado. Miss Adams had never seen any evidence of the son having been choked, and Veronica has never told her of it directly or claimed to have pictures. Wrangler's job with Mr. Cullum gives him flexibility to be available to the children. And then that note says there were previous allegations early in the case by both parties of substance abuse by the other. Wrangler cleans the house, does the laundry, and cooks for the children, and the children are happy and healthy when in his care. And she'd never seen Wrangler deny Veronica phone time with the children when they were with him. Miss Adams also testified Wrangler tries to co-parent with Veronica. but Veronica does not reciprocate. Miss Adams identified plaintiff's exhibit 1 as photographs she had taken of the dog bite on the son's face a week after he had been bitten. She corroborated that Veronica had not told Wrangler about the dog bite, had not made any effort to find out whether the dog had its shots, and had not sought any medical care for the child. She testified to KR returning from Veronica's custody multiple times with turkey peck marks that had broken her skin, and identified plaintiff's exhibit 2 as a photograph she had taken of one of the peck marks on the child. KR was 2 years old at the time and short for her age, so a turkey could easily peck her on the face. Miss Adams identified at trial other photographs she had taken of both children with bruises and marks on their bodies after returning from being in Veronica's custody. Just the weekend before the first day of trial, excuse me, the daughter returned from Veronica's care with a scratch under her eye that she said the dog had given her and a very serious bruise on her privates. Although she is Wrangler's mother, Miss Adams' credibility was enhanced by the fact that initially, when Wrangler and Veronica were having difficulties, she told Wrangler to leave the home and she continued to help Veronica, including financially, to some extent to the exclusion of Wrangler. But Veronica started not coming home after work, bringing her boyfriend to the house where the children were, having parties, and some of the visitors may have been doing drugs in the house. Then one day, Veronica just up and left with the children and did not come back with no notice to anyone. Wrangler testified on his own behalf that he thought the parties should continue to split time with the children 50-50, quote unquote, because I believe that both kids should have both parents in their lives. Nevertheless, he explained clearly why he was a better parent, having shown himself to be more reliable, more responsible, and having provided a more suitable home. He had tried to co-parent with Veronica, but did not believe she had done the same with him. He denied that he had ever blocked Veronica from talking to the children on the phone when they were with him. With respect to the abuse allegations, Wrangler testified under oath that he had never harmed his children and that Veronica had never contacted him directly to question him about any of the allegations. He confirmed, however, that the children had been physically harmed while in Veronica's care and that she would never tell him about it. Wrangler provides financial support, food, and clothing for the children when they are with him. He supervises them when they are outside, and although there are cattle and a dog on his property, the children have never been hurt by the animals, unlike when they are in Veronica's care. His job working for Mr. Colum allows him time to spend with his children. In a typical day, when the children are in Wrangler's custody, he gets up when it's time to get the son ready for school. He gets him ready and gets him off to the school bus. He bathes the children, plays with them, helps his son with his homework when he gets home, and talks with him about his day. He takes the children out to check cattle, and they play and have fun. He cooks and cleans for them, does the laundry, knows their favorite meals, has a routine time for meals and bedtimes, and he puts them to bed at that time. In her own case in chief, Veronica repeated many of the admissions she had made when called to testify in Wrangler's case in chief. She also admitted that her own dog bites the children. She testified to the fact that while the children had been in her care, she left them with a variety of friends and relatives as third-party caregivers while she was working. By the time of the trial, she was leaving them with Debbie Davis, the great-grandmother who made it the 2-year-old daughter's daily chore to feed and water the turkeys that would peck her. Veronica admitted that both Miss Gloud of DHS and Sheriff Berguski believe she is influencing the children with respect to the abuse allegations and that the allegations have no merit. She did not deny the accuracy of their belief. With respect to her alienation of the children from Wrangler, Veronica admitted to telling the children they could call her fiancé Dad. Aside from herself, the only witnesses Veronica called to support her plea for custody were her mother, Amanda, and Wrangler's grandmother, the previously mentioned Debbie Davis. While they, of course, testified generally that Veronica was a good mother, Miss Verner admitted that she only saw Veronica with the children for a few hours at a time on visits every 2 weeks. There was no testimony from Miss Verner regarding having seen the children with Veronica in their home environment. Miss Ferner also didn't know that her grandson had been bitten on the face by a dog. She thought he was nipped or on maybe a leg, or I don't know. And Veronica did not even tell her that. She thinks that the little boy did, or the daughter, which was one of the two. As for Veronica's other witness, Miss Davis, this is a woman who thought it was appropriate to assign a small 2-year-old girl the daily chore of feeding and watering the turkeys who peck her. Miss Davis admitted she had not seen her own grandson, Wrangler, in a year. She also admitted she is not on speaking terms with Wrangler's mother, Tiffany Adams. With respect to her own credibility, Veronica admitted in Wrangler's case in chief that she had illegally received state assistance from the state of Kansas while she was living in Oklahoma. She initially invoked the Fifth Amendment in response to written discovery on this issue because she knew it was illegal. Somewhat mysteriously, she also invoked the Fifth Amendment in response to written discovery, asking her to identify persons she had hired for childcare, what she had paid them, and dates she had used them. Prior to trial, the court entered an order of sanctions against Veronica, ordering her to pay $2,000 of Wrangler's attorney fees for her failure to answer discovery for over a year. Veronica admitted at trial that she had made no effort to pay those fees. She also admitted at trial that she repeatedly neglected to produce documents in discovery, cooperate with counsel, or do the things the court ordered her to do. After hearing 2 days of evidence and from multiple witnesses, the court took approximately a 15-minute break and then returned with a ruling. Despite the fact almost 2 years had gone by, during which the parties had shared physical custody of the children, and the court had heard multiple witnesses during the trial, the judge stated on the record that in making her ruling, she relied on notes she had taken from the hearing on temporary orders back in May of 2019. Inexplicably, and with no stated rationale, the trial court awarded sole legal custody of the children to Veronica. And then this just talked about the review of it. And let's see, the standard of review in custody proceedings is whether the decree is against the clear weight of the evidence. A custody decision will be reversed when there has been an abuse of discretion or this court finds the decision was clearly contrary to the weight of the evidence. Likewise, visitation orders are subject to the abuse of discretion standard of review. An abuse of discretion occurs when a decision is based on an erroneous conclusion of law or where there is no rational basis in evidence for the ruling. An abused judicial discretion is manifested when discretion is exercised to an end or purpose not justified by and clearly against reason and evidence. It is discretion employed on untenable grounds or for untenable reasons, or a discretionary act which is manifestly unreasonable. I'm trying to get past all that there. Okay, so in the present case, Wrangler submits the appellate record is adequate to demonstrate to the district courts that the district court's award of custody to Veronica was clearly against the weight of the evidence, and the record is sufficient for this court to instruct the district court on remand to enter the decree that should have been entered, awarding custody to Wrangler. And then the proposition, it said that the district court's award of custody to Veronica was an abuse of discretion. The decision was clearly against the weight of the evidence. Wrangler recognizes the standard of review in this appeal is very deferential to the district court. Nevertheless, on this record, it is evident that the district court's decision on custody is clearly against the weight of the evidence, and thus an abuse of discretion. Multiple witnesses testified in support of Wrangler's case. The DHS representative, Ms. Cloud, Sheriff Boguski, Wrangler's neighbor, Mr. Sauls, his employer, Mr. Colum, also his mother's boyfriend, and his mother, Miss Adams. Further, as shown above, Veronica's own testimony corroborated Wrangler's claims and his case for custody. Certainly, the weight of the evidence does not mean the sheer number of witnesses. It refers to the power of the evidence to persuade, the quality and plausibility of the evidence, as well as other intangible factors enter into that assessment. However, this court should consider in this regard that Veronica, the principal witness to support her own quest for custody, admitted on the stand to illegally bilking the state of Kansas out of state benefits while she was living in Oklahoma, admitted that neither the sheriff nor DHS found her multiple accusations of abuse against Wrangler to be credible, admitted that she intentionally chose not to work in Elkhart in a conscious attempt to mislead the district court as the convenience of getting the children to the Yarborough school, and admitted that she repeatedly neglected to produce documents in discovery, cooperate with counsel, or do the things the court ordered her to do. These admissions in themselves are sufficiently damning as to tarnish the quality and plausibility of the meager testimony she offered to support her own plea for custody. She gave no testimony of her own claim to parenting skills, nothing about her daily interactions with the children, whether she cooked for them, fed them, did their laundry, helped with the homework, knew their favorite meals, had any set bedtime for them, all the things Wrangler did for the children. Veronica's other two witnesses, her own mother and Wrangler's grandmother, provided little support for her case. Her mother only saw the children every other week and only for a few hours at a time. She did not observe them in their environment in Veronica's care. The children's great grandmother, with her admission that she tasked the 2-year-old with the chore of feeding and watering her turkeys, who were prone to pecking the little girl, her admission that she was estranged from her own grandson and not on speaking terms with her former daughter in law, demonstrated a degree of hostility and eccentricity that rendered her testimony of what a good mother she believed Veronica to be questionable, given her own irresponsible behavior with respect to the children and her turkeys, deliberately exposing the children to danger. Her opinion of good parenting is dubious. Consider also, Veronica admitted a child was bitten on the face by a dog while under her own care, and that she did nothing to make sure the dog had its shots, sought no medical treatment for him, and did not tell Wrangler of the incident. She admitted that she initially did not allow Wrangler to see his children at all when they first broke up. She admitted she's told the child he can call her fiance dad. She admitted to making the numerous referrals to DHS, all of which that agency found to be unsubstantiated. Gotta pause for a second to clear my throat.
It's a lot of reading. It's a lot
It
of good
is a
information, though.
lot. I'm trying to go as fast as I can. Okay, so it was unsubstantiated, and to request then the law enforcement supervision of visitation exchanges that the sheriff testified was unnecessary and a waste of law enforcement resources. That makes me mad. She objected to changing a child's name so that he would have the surname of his father, Wrangler. She claimed whether he carried the name of his father should be the child's decision at some point. Wrangler was forced by Veronica to file a motion requesting an order from the court for the name change. An abuse of discretion occurs when a decision is based on an erroneous conclusion of law or where there is no rational basis in evidence for the ruling. The record in this case reflects there was no rational basis in the evidence for the district court's ruling granting sole legal custody of these two young, vulnerable children to Veronica. You say the decision was against the best interest of the children, despite the district court's discretion in awarding custody and visitation, quote unquote, the best interest of the child must be a paramount consideration of the trial court when determining custody and visitation. The determining factor in this case, as in all such cases, must be the effect of the questioned behavior on the welfare of the child. To establish an abuse of the trial court's discretion, there must be a showing that this requisite nexus is present and that the effect of the behavior is detrimental to the best interests of the child. In the case, the court recognized it is appropriate for the trial court to consider contemptuous conduct by one parent in determining the welfare of the child. Accordingly, the district court should have considered Veronica's admissions that she had repeatedly failed to comply with court orders and had attempted to intentionally mislead the court with respect to her ability to work in Elkhart and the corresponding convenience of the Yarborough school in determining the welfare of these children. Clearly, it did not. Because the best interest of the child must be the paramount consideration, the same holds true for all relevant conduct of the parents. not just what might be deemed moral transgressions. Where the parental behavior in question has a negative impact on the welfare of the child, an award of custody to that parent is an abuse of discretion. Veronica's admitted behavior has negatively impacted the children. In addition to the emotional impact, her stable unemployment and multiple relocations have had on the children. There was undisputed being winter care. Additionally, that one parent's work schedule makes them more available to the minor children weighs in favor of awarding custody to that parent. The district court ignored that Veronica's erratic work schedule required her to leave home sometimes as early as 4:30 in the morning and return home sometimes as late as 7 at night, leaving the children in the care of a wide variety of caregivers, including her fiance, her friends, and Wrangler's eccentric grandmother. Wrangler, by contrast, had steady employment in a job with flexible hours that allowed him to be available for his children when they need him. By statute, the district court should have considered in making its custody decision which parent was more likely to allow the children frequent and continuing contact with the non custodial parent when such contact is in the children's best interest. Wrangler testified to his belief in the importance of the children having both parents in their lives. Veronica, on the other hand, denied Wrangler any visitation when the parties first ended their relationship, sought to estrange the children from their father with her numerous bogus referrals to DHS and requests for law enforcement supervision of visitation exchanges, refused to permit one of the children to participate in the school Christmas program, allegedly in consideration of the 4-year-old having stated he didn't want to participate, and encouraged the children to call her fiance dad. The district court's custody decision was contrary to the best interests of the children. Accordingly, it should be reversed, with instructions from this court to enter an order awarding primary physical custody of the children to Wrangler and visitation to Veronica. If the appellate record is sufficient to show a decision has been made contrary to the weight of evidence, then this court will render the decree in equity the trial judge should have rendered. So the conclusion, the evidence at trial and reflected in the record on appeal showed Wrangler to be a mature and responsible father. He maintained a clean home where the children were well fed and cared for when in his custody. He held steady employment with flexible hours that permitted him to be available to the children. Wrangler made efforts to co-parent with Veronica and stated his belief in the importance of the children having both parents in their lives. Multiple witnesses supported Wrangler's case, including but not limited to the clearly unbiased DHS representative, the sheriff, and a rancher neighbor. In contrast, the evidence at trial and in the record of this appeal showed Veronica to be unstable, irresponsible, dishonest, and neglectful of the children's welfare. By her own admission, she defrauded the state of Kansas out of state benefits, and she ignored and disregarded court orders. She admitted to making multiple, ultimately unsubstantiated allegations to DHS of alleged abuse to the children by Wrangler. She admitted to being fired from a job for unreliability and to having walked off another job. She admitted to attempting to deceive the court to try to influence the court's decision. She admitted to her multiple relocations. She admitted to not seeking any medical treatment for the son when he was bitten by a dog, or even bothering to verify if the dog had its shots. She admitted to leaving the children in the care of their great grandmother, who was either incapable of or unwilling to adequately supervise them around her turkeys to prevent injuries to the children. On this record, the district court's award of sole custody of the minor children to Veronica was an abuse of discretion. The decision should be reversed with instructions to award custody to Wrangler with visitation awarded to Veronica. Wrangler Rickman respectfully requests this court reverse the custody and visitation order of the district court and render the decree that should have been rendered, granting custody to the plaintiff, Wrangler Cole Rickman. And that was the end of that. That was served on February 22nd. So, wow.
Good night. It doesn't look, it just sounds like a couple of kids that have been weaponized between
Oh my
two
gosh.
angry people.
Totally, totally. So, Let
That's
me
sad, but
see.
it's typical, right? That's not unusual
Right.
for folks to fight over their kids. I get it. It's just hard to see it in black and white and knowing what its outcome was.
It's horrible. Do you wanna read this next one? It's a lot shorter. That was the longest document, I believe. You wanna read this next one here?
What's the next one? Is it where are we going at? What do you got?
Or I'll read this and then okay, so Wrangler appeals that, right? On August 5th,
Okay.
2022, Wrangler filed an appeal in a higher court to get custody of the children. That appeal was granted as joint custody. On December 7th, 2022, Wrangler was able to get full custody with Veronica having supervised visitations only. So he did appeal it to the higher court. They were granted joint custody. And we have that document right here.
There we go.
Let me make it a lot bigger. All right. I'm going to mute myself and I'll keep an eye on the chat here.
Okay. Give me a second so it appears on my screen. Oh, let me see if I can enlarge that. Okay. So what we have is the opinion by Robert D. Bell, presiding judge. In this paternity proceeding, plaintiff appellant Wrangler Cole Rickman, which is the father, appears from the trial court's order awarding sole custody of the parties, minor children, to defendant appellee Veronica Claire Butler, who's the mother. Mother did not file a response brief in this appeal. Therefore, this appeal proceeds on father's brief only. After reviewing the evidence in the record and father's brief, we find both parties are fit, capable, and loving parents who were successfully co-parenting under shared custody arrangement during the course of the custody proceeding. Let me see if I have to manipulate my screen a little bit. Can you scroll up just a little bit for me? Okay, let me pull the chat down so I can try to blow this up a little bit. Okay. All right, where was I at? Okay. In this paternity proceeding, so I need to go back down. After reviewing the evidence, I got it.
Are you able to scroll through that?
I can see.
Can you scroll
I
through
can't
it?
scroll through it. No, I
Okay,
can't
I'll
scroll
just
through
keep
it.
up
Not
with you
from.
then. Okay, I'll keep up with you here.
Sweet. Okay, where did I leave off at? See, don't do that. We further find the children were well cared for and benefiting from the shared custody agreement. Oh, wait, did I mess up? I did mess up, didn't I? After reviewing the evidence in the record and father's brief, we find both parties are fit, capable, and loving parents who were successfully co-parenting under a shared custody agreement during the course of the custody proceeding. We further find the children were well cared for and benefiting from the shared custody arrangement. When the weight of the evidence demonstrates that the parents are able to act in the children's best interests, Oklahoma law favors shared parenting custodial arrangements. We therefore find the trial court's order awarding sole custody to mother is contrary to the weight of the evidence in Oklahoma shared parenting policy and is therefore an abuse of discretion. The trial court's order is reversed, and this matter is remanded to the trial court to enter a shared custody arrangement. The parties were never married. The party's son was born December 18, 2015, and daughter was born April 2, 2018. The party's relationship terminated December 2018. On February 27, 2019, father instituted an action to determine his paternity and to share custody of the children. The trial court entered a temporary order granting custody to mother and visitation to father. In the summer of 2019, the parties agreed to share physical custody of the children every summer of 2019. The parties agreed to, my bad. The parties agreed to share physical custody of the children every other week. The court later memorialized this shared custody arrangement. The trial on the custody matter was held over 2 days, January 19, 2021, and February 26, 2021. Both parties testified and presented multiple witnesses on their behalf. The witnesses generally emphasized both parties became parents at a very young age, but over time, the parties have matured and become more stable. Father's evidence showed mother moved several times with the children between Oklahoma, Kansas, and Colorado without prior notification to father, and that mother held several jobs. Mother's evidence reflected that after the initial disruptive transitional period, she settled upon a more permanent residence and employment as a nurse. Mother's witnesses testified that mother is a loving and attentive parent. Father's evidence disclosed that he maintains a flexible job working as a farmhand. He provides the children with a clean and well-kept home and is an available and, you scroll up for me, doting father. The parties' primary disagreement pertained to the school the children should attend, mother's choice of caregivers, and mother's decisions not to notify father or seek medical attention when the eldest child was bitten by a family dog. Father's evidence also focused upon mother's numerous unsubstantiated referrals to DHS and Kansas authorities involving accusations of father's neglect, abuse, or harm to the party's son. Mother also requested civil standbys during custodial exchanges. Go ahead and scroll up for me. Will you scroll up for me, Carrie? Custodial exchanges which were terminated by the sheriff due to uncorroborated claims. Father testified under oath that he has never harmed his children and that mother never contacted him directly to question him about any of the allegations. Father testified he would be agreeable to shared parenting with the children 50-50 because I believe that both kids should have both parents in their lives. Mother testified she agreed to shared custody prior to the trial and never sought any emergency orders based on her referrals to DHS and Kansas authorities. At the end of the second day, the court announced on record that it relied on notes taken at a hearing on the temporary order in May 2019 and awarded sole legal custody to mother and standard visitation to father. The trial court's notes are not part of the appellate file. Father now appeals from this order. This is an initial custody proceeding. As such, the trial court is authorized to award custody to either parent or both parents jointly. According to the best interests of the children, let me read that appropriately. In reviewing a trial court's initial custody of the children, In reviewing a trial court's initial custody determination, this court will not reverse the trial court's order unless it is contrary to the clear weight of the evidence concerning the children's best interest or affected by an abuse of discretion. Daniel v. Daniel, 2001, Oklahoma. That's the case study there. An abuse of discretion occurs when a decision is based on an erroneous conclusion of law or where there is no rational basis in evidence for the ruling. And there's another case study reference there. The paramount consideration in an initial custody determination is the children's best interests. And they go on to cite more case there. So we can scroll on down. And then it goes on to say, mother failed to file a response brief, and this appeal proceeds on father's brief only. Where there is only an unexcused failure to file an answer brief, this court is under no duty to search the record for some theory to sustain the trial court judgment. And where the brief in chief is reasonably supportive of the allegations of error, this court will ordinarily reverse the appeal judgment with appropriate directions. So we have more case law there that's recognized. However, reversal is never automatic on a party's failure to file an answer brief. If the record presented fails to support the error aligned in the brief of the party who lost below, the decision is to be reviewed. The decision to be reviewed cannot be disturbed. It is presumed correct until the contrary, let me enlarge that just a little bit, sorry. It is presumed correct until the contrary is shown by the record. After reviewing the record, we find the allegations of error in father's brief in chief are reasonably supported by the weight of the evidence, and that the children's best interest would be served by ordering the parties to share legal custody of the children. We acknowledge both of these very young and immature parents presented conflicting testimony about the other party's inappropriate behavior and choices. Nevertheless, the evidence reflects both parties are attentive, loving, and fit parents. The evidence demonstrates the children are nurtured and comforted by mother. We can scroll down. Yeah, you can keep going. I can't see all of it just yet. Will you scroll for me, Carrie? There we go. They are well cared for by both parents, and the children appear to be happy and excited to be with father. Father has taken significant steps throughout this proceeding to establish and maintain his relationship with the children. When the evidence reflects two fit, attentive, and devoted parents, and when the circumstances allow, the Oklahoma legislature has deemed it in the children's best interest for the parents to share the rights and responsibilities of rearing the children, which provides that when it is in the children's best interest, the court shall assure frequent and continuing contact with both parents, and the court shall encourage parents to share the rights and responsibilities of child rearing. We can see the trial court declined to order joint custody because it found these parties do not cooperate. However, the record shows mother continued the weekly custody arrangement with notwithstanding her frequent relocations and referrals to DHS and other authorities. The record also shows the parties successfully co-parented since 2019. We therefore conclude the trial court's finding was contrary to the weight of the evidence. When the trial court's judgment is clearly against the weight of the evidence, this court may reverse the judgment or render, or cause to be rendered, such judgment which is this court's opinion the trial court should have rendered. Based on the record before, we can go ahead and scroll down. Based on the record before, yeah, you can keep going. I can't see that. There we go. Based on the record before us, and because we decide this matter on appellant's brief only, we hold the children's best interest would be served by continuing the joint custody arrangement that was working prior to the trial. Accordingly, the trial court's custody decision is reversed, and this matter is remanded to the trial court to enter a shared custody arrangement. Therefore, it is reversed and remanded. Court documents are fun.
Oh, yes. All right.
So much
So
fun.
that was the end of that one. The next one that we do have are the supervised visit orders. There's, you know, there's a big piece of it that we don't have because I was not able to grab them before they were locked down. But so this is the next one that I do have. On November 21st of 2023, the orders for the supervised visitation, mainly the people that would supervise them, was filed in Cimarron County Court. And let me see. Whoop. Just a second, get that. Okay. Unfortunately, I can't make it much bigger than that. I can't at all because it's a picture and it's not going bigger. Okay. So this was the order filed November 30th of 2023.
Mhm.
Now on this 21st day of November 2023 comes on for hearing the issues of prospective supervisors for the defendant's visitation. So between what we read last and this document, there is another one. And that one removed, it made it to where Veronica could only have supervised visits. So that's what we do not have. So on the 21st day of November 2023 comes on for hearing the issue of prospective supervisors for the defendant's visitation. The plaintiff, Wrangler Cole Rickman, appeared in person, pro se. Defendant, Veronica Clara Butler, appeared in person and by and through her attorney. And intervener, Tiffany Adams, appeared in person and by and through her attorney, William Jewell. After reviewing the filings of the parties and hearing arguments of the parties, the court finds and orders as follows. The intervener, Tiffany Adams, shall inform the defendant, Veronica Butler, every Wednesday whether the approved supervisor, Cheryl Brune, is available to supervise the upcoming Saturday's supervised visitation. The intervener, Tiffany Adams, shall be responsible for any and all supervision fees charged by Cheryl Brune. Defendant's supervised visitation shall take place exactly as ordered herein on December 7th, 2022, and filed herein on September 25th, 2023. In the event that the approved supervisor, Cheryl Brune, is unavailable, the intervener, Tiffany Adams, shall notify the defendant, Veronica Butler, by Wednesday at 5 p.m. And then the defendant, being Veronica, shall be allowed to use any of the following as approved supervisors. And it lists the names. And obviously, sadly, Miss Jilian Kelly is the third name on that list. None of the parties to this case shall have the unilateral authority to cancel any visitation, nor disqualify any of the above mentioned court-approved supervisors. If any party should have a problem with a visitation or a supervisor, said party shall file a motion and a hearing will then be held regarding said motion. All visitations shall continue unless and until there is an order of this court stating otherwise. Supervised visitation shall take place on Saturday, November 25th, 2023, and shall continue on each and every subsequent Saturday as currently ordered until further order of the court. And then I didn't get the last part of it, so I have it this way. But the next one, Miss Cheryl Brune has supervised all of the defendant's visitations with the subject minor children and is aware of the hearing date on April 17th, 2024 at 1:30 p.m. That is currently scheduled in this matter and has been subpoenaed to appear that day to attest as to her observations of the defendant's visitations with the subject minor's children. Ms. Brune has not filed nor brought anything negative to the attention of counsel for the defendant regarding her visitations with the subject minor children. The defendant requests this court to allow the defendant to have unsupervised visitations with the subject minor children on our already scheduled Saturdays from 8 to 5 p.m. with the parties meeting at Elkhart, Kansas, which is closer to halfway for both parties rather than Four Corners for exchanges of the minor children. Now, I'll tell you guys that, Wrangler's grandmother told me she was doing this because she was already not safe. She'd already been receiving threats. So she was trying to get that location changed to a much safer one. The defendant would request that said unsupervised visits continue for 4 consecutive Saturdays and then step up to every weekend from Saturdays at 8 a.m. until the defendant returns the minor children at 5 on Sunday evenings, with the parties continuing to meet at Elkhart, Kansas for exchanges. The defendant would request that said unsupervised 1 overnight visits continue for 4 consecutive weekends and then step up to every weekend, with the parties meeting at 8 a.m. on Fridays. The minor children do not have school on Fridays, with the defendant returning the minor children to the intervener, Tiffany Adams, at 5 p.m. on Sundays. The parties regarding the child not being around the subject minor children would, of course, remain in place. The defendant believes the increased visitation to be in the best interest of the minor children, and the defendant was Veronica in this one. On November 8, 2023, Veronica filed as the petitioner against Tiffany regarding her withholding the children from both her and Wrangler. Wow.
What you got there?
I don't know. Okay, here we go. All right. So then this is when, so Veronica files this against Tiffany on November 8th of last year. And I think what I just read, no, didn't, it's not on this one. Okay. So comes now the petitioner, Veronica Butler, and alleges as follows. Number 1, any and all allegations set forth in the petitioner's motion to modify and motion to enforce visitation as filed in Cimarron County, case styled, blah, 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 on October 27th, 2023, shall be as if they are set forth fully herein as well. The current orders controlling custody and visitation rights with regards to the subject minor children were entered herein on December 7th of 2022 and filed on September 25th of 2023. Insofar as it pertains to this petition, the prior order has not been modified by this or any other court and remains in full force and effect. The last period of specific visitation that Veronica was allowed to exercise with her minor children took place on July 1st, 2023. Now, this is at the time of the document. Veronica did indeed see the children a couple of weeks prior to the horrific incident. The last period of specific visitation that took place on July 1st, the petitioner had a supervisor with her, Miss Nylene Johnson, for her last visitation. The respondent, Tiffany Adams, has had exclusive possession of the minor children for the past several months and is withholding them from both parents currently. This is not in the best interest of the children and is in violation of the court's orders. The father of the minor children, Wrangler Cole Rickman, the son of the respondent, Tiffany Adams, has himself posted on his Facebook account about his mother withholding the minor children from the petitioner and himself in violation of the law and the current order as outlined. The respondent, Tiffany Adams, has not to date filed any action for grandparental visitation rights, nor has she filed any action to procure guardianship of the minor children. As such, her possession of the minor children is in violation of this court's orders and the laws of the state of Oklahoma. The venue is proper with this court as the respondent, Tiffany Adams, is holding the children with her at her address in Keys, Oklahoma. The respondent, Tiffany Adams, is currently in violation of the Oklahoma criminal statute, child stealing, which is a felony offense punishable by up to 10 years in prison. All elements of said crime are present by the actions of the respondent. This court should enter its writ of habeas corpus to respondent Tiffany Adams, demanding that she produce the minor children before this court. In the alternative, this court should order the sheriff to immediately take possession of the minor children away from the respondent to allow the children to be brought before the court. Wherefore, petitioner Veronica Butler prays that this court immediately issue its writ of habeas corpus to respondent Tiffany Adams, demanding that she produce the minor children before this court on a date certain, or in the alternative, that the court order the sheriff to remove the children from the respondent to allow them to be produced before this court, and for such other and further relief that the court finds to be inequitable in the premises, including reasonable attorney fees and court costs. So the grandmother of Wrangler has told me they did go to the sheriff. They're like, the court order says she's supposed to be able to have visitation. And the sheriff basically said they didn't give a crap what the court order had to say. So keep in mind that sheriff's name for future, because he's no longer a sheriff there, but keep that name in the back of your mind because there's more to all
Agreed.
that. All right.
So I know it was mentioned in the comments, yes, the court documents are boring, but if you go through Facebook, our group, any group, anybody that's commented on any of the court documents, there's been a lot of parental bashing regarding Veronica and Wrangler. And so it's very important to lay the groundwork as to what built up to where we're at today.
Definitely.
It's not
all big. It's all a major important part of the whole thing that's gone down. One of the big parts of it, for sure.
Yes. And it has to be laid out completely as possible so that it's understandable. And we would be remiss if we did not go through it basically word by word as we just did to make it clear. This was a back and forth. Both parents were trying. Both parents they were trying on different levels in different ways, and they had finally were coming to a pass. And so it's boring, but it's necessary.
Right. All right. You want to read this one? It's just a short page. I have retracted some information in it, but it's just a really short page.
Yeah. So we have here, let me enlarge my screen just a little bit. Wow, I'm getting all kinds of stuff. Let's turn that off.
So I guess I should explain it real quick. This is another one of those documents that I wasn't able to get the full document, but I screenshot right then what was the important part that I'd seen. So this is actually Tiffany's response. So a portion
Okay.
of what we're able to obtain anyway, this is a part of Tiffany Adams' response to Veronica wanting that increased visitation and all of that I just read. Okay.
Okay. So the reason is because obviously Mr. Rickman trusts Ms. Adams with the children more than he trusts petitioner with the children.
Oops,
Mr.
Tara, I
Rickman
didn't
may
have it at
be,
the beginning. Okay,
oh,
it's
you're
back. It's
fine.
at the beginning now. Okay, sorry about that. That was my bad. I'm sorry.
Oh, you're fine. There we go. Okay. I was gonna say it's kind of an odd place to start, but I'll go with it. Whatever, that's fine. I'm not legal. Okay. So something doesn't smell right. Petitioner appears to be capitalizing on the indifference Mr. Rickman has shown for his children. Mr. Rickman has removed himself from the children's lives. Instead of being a father, he now seeks the pleasures of drinking alcohol, using drugs, and other degenerate behavior. When he left the children in his mother's care, not in petitioner's care. The reason for this is twofold. First, it would have been a violation of the court's order granting Mr. Rickman temporary emergency custody for him to leave the minor children with petitioner. This is because, and the point cannot be stressed enough, it's redacted there. So the second reason is because obviously Mr. Rickman trusts Ms. Adams with the children more than he trusts petitioner with the children. Mr. Rickman may be at odds with his mother, but it's easy to understand why he left the children with Ms. Adams when petitioner allows the children's abuser to be around them and lies about that fact to the court. Gonna pause right there. There's been a lot of rhetoric on the Facebook. We've controlled that rhetoric because it involves minor children all the way around. We don't go into the details of that, but this is where when the sexual assault stuff, the sexual abuse stuff, that's where it comes into play. That is not up for debate. It's just what Tiffany has taken to the courts at this point. Okay, for these reasons, notwithstanding the jurisdictional defect described above, it would be unconscionable for this court to give petitioner any more visitation with minor children than the court has previously ordered. The minor children need someone to protect them, and Ms. Adams has risen to the occasion. Taking the children from Ms. Adams' care and placing them into the care of the petitioner is not in the best interests of the minor children, and the court should deny petitioner any relief in this matter. Wherefore,
And that's all we have
premises,
right there.
is that it? Okay, so that's
That's
the end of it.
that's the end of that. So that was her response to Veronica trying to get her visitation increase and what have you. Then the next thing we have was on March 13th. That was just a couple of days ago. Tiffany Adams' attorneys filed a motion to withdraw as her counsel for her being an intervener. They are also Wrangler's attorneys, but they withdrew from representing Tiffany as the intervener. And let me get that real quick. All right. So this is it's still in the case of Wrangler versus Veronica, but this is regarding Tiffany. Motion to withdraw by counsel for intervener Tiffany Adams. Comes now the attorneys of record for the intervener Tiffany Adams and moves this court for an order allowing the withdrawal of the attorneys as counsel for Tiffany Adams, and in support thereof assert as follows. In this matter, intervener retained the undersigned counsel to represent her, and an entry of appearance was filed by the undersigned counsel on her behalf on November 14th, 2023. So that's when she was trying to fight Veronica, okay? They entered that entry for her. Circumstances have subsequently arisen which constitute an irreconcilable conflict of interest between Tiffany and her counsel. There is an irreconcilable difference of opinion that makes it necessary for the undersigned counsel to withdraw. Intervener has violated her contract for representation in this matter with the undersigned counsel, which makes it necessary for counsel to withdraw. Intervener has requested counsel to withdraw from the case by email dated March 6th of 2024. Counsel informed intervener of their intention to withdraw by email and voicemail message on March 8th of 2024. Intervener has not yet retained new counsel. The final hearing in this matter is currently scheduled to occur from March 25th to March 28th. It says her address. The council moves the court to grant intervener an additional 30 days to retain new counsel and by implication continue the final hearing on March 25th. In addition, circumstances have arisen within the previous 7 days, which will require the trial to be continued, notwithstanding counsel's motion to withdraw. First, the undersigned counsel represents a current judge of the district court in Oklahoma before the judicial regulatory body of the state. Wonder what judge that is. In the past 7
I'm not sure.
days, counsel and their judicial client have been subpoenaed to appear before this judicial regulatory body for a hearing on March 28th, the last scheduled day of the trial. Counsel was not consulted by this regulatory body before the hearing date was set, and the regulatory body is likely not inclined to grant a continuance of that hearing. This presents a situation where even if the trial concluded on March 27th, it would be virtually impossible for counsel to travel from Boise City to Oklahoma City and have sufficient time to prepare before the regulatory hearing. Also, lead counsel for Tiffany Adams, who is specifically retained to represent her, was admitted on an emergency basis at 3:30 a.m. on Wednesday, March 6th, to Integris Hospital in Edmond for a life-threatening medical condition. This emergency and life-threatening medical condition requires lead counsel to undergo a surgical procedure in Dallas, Texas at Medicine City Hospital on March 19, 2024. Counsel has been informed that he would be in the hospital for a minimum of 2 days to allow for that procedure, and he must have a diagnostic assessment the day before the procedure. Counsel will require at least 5 days of rest following the procedure, which in all likelihood would mean this trial and possibly the hearing before the judicial regulatory body will have to be continued because of lead counsel's unavailability. This was unexpected and resulted from a series of routine examinations, evaluations, and tests conducted at Integris Bass Hospital in Enid and at Integris Edmond. Counsel is under the care of board-certified heart specialists, the regular cardiologist in Enid, and one in Oklahoma City. Counsel has written confirmation of the emergency nature of this matter, and so together with all the considerations described in this motion, it is better that counsel be allowed to withdraw in accordance with their client's wishes and the unavoidable medical emergency. A proposed order allowing withdrawal is attached. So basically, Tiffany wanted to fire the attorneys. They wanted to fire Tiffany. They couldn't get so the attorneys have to. They really need to do what's in the best interest of the children. It seems to me that they had caught wind of some of this stuff that was going on. And at that point, they were no longer going to represent her. That's kind of how I read it.
Mm-hmm.
And as well as the lead attorney having a medical problem. But that certainly, I don't think was the sole reason.
No, agreed. Definitely. I think, I don't know if anybody else would agree with me. There's a pattern of behavior starting to emerge here, whereas I think Tiffany's concerned. We're starting to see some things that you don't get to see on Facebook discussion
Definitely.
polls. You really have to get into the documents, as boring as they are, and deep dive into what is really happening, what's going on, and who had what rights where and when it was in regards to the children.
Yeah. The Wrangler's grandmother did tell me that she was told. Now, I don't know. I don't know if she got the court documents or if this was another, attempt of Tiffany's, but that Tiffany had temporary custody of the children. So I don't know what's going on with that, but yeah, and I tend to believe that because they didn't get the kids any sooner. Like I know that they were in school all that week and stuff like that. So I kind of feel like maybe she did, but we just haven't been able to see that because that's all locked down now. I don't know,
Well,
but that's kind of a thought I had.
I think that's agreeable with Wrangler having some legal issues that turn into going into rehab, and him having the custody or shared custody, whatever the agreement was. The children had to go somewhere, so maybe he signed over a guardianship or something that was temporary for somebody standing in for him while he was away for 6 months. is maybe what that regards. I don't know that that would certainly come to my mind in all of this because she had them, and I believe they attend school in that
Yes.
area,
Yep, they do.
and so somebody had to give her something to allow her to do what she would need to do for the next 6 months.
Yep.
There had to be
And
something there,
Courtney,
and then we are aware that there was a court date for April 17th, so there was something still going on. Um,
yeah,
I don't know.
Veronica was definitely trying to get custody back of her kids now
Mhm.
that Wrangler, had been locked up. He did have a serious charge against his current wife who is pregnant. It looks like that was
Mhm.
dismissed, but in order to have it dismissed, possibly, I'm not sure because that stuff's kind of locked down too. But
Yeah.
he had to go to rehab for 6 months. In the first 30 days, he's not allowed any contact, with anybody on the outside. So I know that the grandmother, his father, nobody's been able to talk to him yet. He did have a
Correct.
counselor in there, and I know that OSBI obviously talked to him. But so
Yep.
yeah, I agree, Courtney, that the irreconcilable differences was very
Mhm.
likely that she had told her attorney she had no intention of returning the children or allowing more visitation. And I agree because she told the judge that. I mean, she said, she loses the kids, bodies will drop. So there's that.
Yep.
She didn't have any
Yeah.
intention of it at all.
I agree, Phoebe. Veronica's trying to get her life on track, and Wrangler may not have been trying as hard, or may have gone a different direction, but there's definite. So the patterns are starting to emerge. Things are starting to make a little bit more sense as to what led up to the events of the last 2 weeks, and
Right.
they were messy. They were absolutely messy.
Very. And yes, Veronica really had gotten, her life together. She had bought that business. Her fiance is a police officer there locally. And, it sounds like to me like she really was doing a great job. And a lot of this, I'm just going to, my feelings, a lot of it, is grandma pushed a whole lot of it. Wrangler wanted to work with Veronica. He wanted them to both have custody. That he did that the whole time. I
Yeah.
think a lot of these court filings that we see was probably Grandma Tiffany pushing, the issue. And we've seen that, there is a document, and I could pull it up maybe when
It,
Tara's talking, but there is, it was a part of the document that a lot of people were able to grab that she had threatened
mhm.
him and put a gun to his head. She wasn't letting him see the children either. So grandma is just like took these kids and she was trying to make them her own and who knows what else. Um,
Yeah,
so
that document, I remember that specifically. That blurb was September of last year. And it said that basically I had to do what my mother was telling me to do because she threatened to put a gun to my head. I have to do these things. She's forcing me.
yes,
Um,
exactly.
and so that makes you wonder. It causes to question because, right, one lie makes you question the entire truth. It kind of makes you wonder about all of the proceedings we just read. Was it really Wrangler going after that, or did he have some sort of a driver behind him in the way of his mother? So it's very questionable. It doesn't look, and it obviously doesn't look good because it didn't turn out good um, for anybody in the case, particularly the children. And so there's a lot going on. The comments are coming in, and I agree.
Yeah.
The temporary emergency guardianship. That's where it's at. That's exactly what I'm thinking, Cannon.
So as
Um,
far as the schooling, Courtney, they did attend a school, but you're pretty much right. It was like a homeschool co-op. So
mhm,
you're right. They didn't have to report them not at school or anything like
mhm.
a regular school would have to do. And I do have that was said on the screen now. And like I said, that's in another document that we couldn't access. But it says the defendant and the plaintiff have had a telephone conversation that took place extremely recently. Now, defendant and plaintiff are Veronica and Wrangler in this case,
Yeah,
September 22nd of 2023, wherein the plaintiff, Wrangler, admits that he never disapproved of any of the supervisors that Veronica had chosen for her supervised visitations, and that it was his mother that would make that decision, and he felt compelled to listen to her. The plaintiff further stated that he had been threatened numerous times by his mother that she would kill him, shoot him in the head if he didn't
mhm.
do what she told him to do, that he would send the plaintiff copied and paste text directly from his mother as if it were him. that the plaintiff believes his mother has cops in her pocket, quote unquote. And she did. Most importantly, the plaintiff admitted that he believes that his mother coaches and has coached the subject minor children before dropping them off with their current counselor. So that's why I say this is grandma. This was not a battle or a fight between Veronica and Wrangler at all. I just don't think it ever was. He established in the beginning, he established, that he was the father. They did the DNA thing, all that. They established the initial custody agreements, things like that through the courts. But it seems like from what I have heard, that they really did work pretty well together until, here grandma came along and destroyed everybody's world.
Yeah, there's an interesting question in the chat from Jamie Lee. I mean, all her kids were grown and gone. Why was she obsessed with these kids? It's a question that yields to speculation right now. Given some of the things that Carrie and I have learned, it could be any number of things. There's been some chatter in the Facebook group that, and I'll kind of quote it. I'm going to paraphrase it because I don't have it in front of me. Basically, she screwed up her 3 kids, and her grandkids were her way to, rectify those decisions with her kids. I don't know that we have a good example of that given recent events, but I think with some of the concerns with the sexual abuse that it may have been coached, may have been real, that's not for us to debate, and the belief system that Tiffany seemed to be involved with, the group that's been mentioned, which is the God's Misfits, and it just seems like maybe there was, I don't think it was just about the kids. I think Tiffany's belief system and lifestyle were incorporating and empowering her to pursue these children. I think she felt like she was doing the right thing despite how non-mainstream it is.
Right. Like she really believed in all this. Like, I mean,
Get to her, it was the
Daybell.
right thing. Yep. She was doing the right thing and everybody else was wrong. And she had a group of people behind her saying, go Tiffany, is what it boils down to, I think. So that's the best we can come up with based on everything that we know. So I want to address, I've seen it a couple times, Satan's misfits. I get it. It's sending a message that these people are evil. And based on what we have heard, we've heard some varying things about the God's Misfits, and we can get into them a little bit more later. They are a group of people that get together weekly, have some potluck, do some prayer. So they don't partake in satanic rituals. Granted, they're not partaking in anything that the public generally agrees with either. But they're very, in terms of the religious belief gatherings and welcoming others into their belief system, they don't have an open door policy. I've heard multiple times it's an invite only. It's a very tight-knit group. It kind of reminds me of other groups where they don't want to invite law enforcement to handle their legal problems, civil problems. They'll do it on their own, is where I think this group really lends itself to. So I just want to be clear, I haven't heard anything satanic or ritualistic like that.
No,
just an extremist group, just a small, I say small, I don't know how small it is, but it doesn't sound like that's the culture of the general area out there.
No,
a lot of
not at
people
all.
did not like the term cult, and I understand why. It is just a very extreme religious group that does tend to have belief system that looks like Christianity, but I'm not interested in learning more about it in terms of being a part of it. I'm interested in learning more about it to see why people were making decisions that they were making. So I want to put that out there so that it does not appear that we are calling these people satanic. We really don't know the depths of their religious beliefs. We just know that the ones that we've identified in this whole big ordeal seem to all be linked back to God's Misfits.
Yes. And they are actually, so they call themselves God's Misfits. We know that for numerous reasons, but Cole himself made multiple posts calling them God's Misfits.
Yes. He did. He was not shy about those posts either.
They are actually American state nationalists. So Tara
Yes.
and I are going to present a whole lot of information on this group, who's in this group, what this group does, all of that, hopefully really soon. We just wanted to be able to do this since we have not yet gone through all these documents with anybody, and there's still so
Hmm.
many questions about them that hopefully, everybody can get caught up from, what started happening with the custody and up till now. And then Tara is going to go over the charges and the probable cause statements from today.
Yes, you may do that now because
Yeah,
it's
if you can make it like
oh,
bigger, just
okay. So you can't see me. Okay.
yeah.
Surely I can make this bigger. Woo! Is
There,
that
yeah,
good?
perfect. That's perfect.
Perfect. Okay. So let's go through this fun ordeal, shall we? And I use fun very loosely and sarcastically and snarkily because it's just wow. So what we're looking at here is we're looking at the probable cause warrant for Tad Burt Cullum. Okay, and we've redacted the information that it would be the right thing to do. So the state of Oklahoma and county of Texas, um, we've got the undersigned district attorney of the county of Texas there. That is George H. Leach III, which I think we saw him on the press conference today. And so he is charging on behalf of the state of Oklahoma. He's charging Tad Cullum with murder in the first degree, deliberate intent, a felony, which is aiding and abetting in the commission of the deliberate and intentional taking away of the life of a human being on or about the 30th day of March, 2024, and then in there willfully, unlawfully, and feloniously without authority of law, aid and abet in the death of Veronica Butler, who was lured to the location of Highway 95 and Road L in Texas County, Oklahoma. And certain mortal wounds were inflicted, and Veronica Butler did in fact die as a result of these wounds inflicted. Let me stop real quick. For family members, loved ones, and those who are closely impacted by this, I know reading this out loud is not fun to hear, and so I apologize to you. And I honestly offer you my. I don't mean to be insensitive. Reading a legal document is never a sensitive thing to do, so I apologize for the way this sounds. The second count of murder is the exact same charge in relation to Jilian Kelly, and so we move on to the kidnapping charges. We talked about this earlier today. It's a felony on or about the 30th day of March, 2024, aiding and abetting the forcible seizing of Veronica Butler, and in this case, as a second charge, Jilian Kelly from Highway 95 in Rodell, County of Texas, Oklahoma, confining Veronica in another vehicle along with Jilian Kelly and transferring said victims to another location without lawful authority and with the intent to cause Veronica Butler and Jilian Kelly to be confined, imprisoned against her will. And then, and this kind of ends up being a biggie with some of the things that we learn in this affidavit. Conspiracy to commit murder in the first degree, deliberate intent, it's a felony. Conspiring and agreeing with Tiffany Adams, Cora Twombly, Cole Twombly to commit the crime of murder in the first degree, a felony, on or about between the 13th day of February 2024 and the 30th day of March 2024 by arranging and planning the deliberate, intentional, and unlawful taking away of the life of Veronica Butler and or Jilian Kelly, and the defendant and or co-conspirators did purchase burner phones, stun guns, and traveled to the area of Highway 95 in Rodell, County of Texas, Oklahoma, in furtherance of the conspiracy. That timeline is important and new because we had all been focusing on the March 30th day. And law enforcement is saying, no, we're going back to February 13 when in terms of conspiracy for all four individuals, Tad, Tiffany, Cora, and Cole. That's a biggie. And you'll find out in this affidavit why if you have not already read it. So we're going to pass through the witness section, and these are just the legal people that helped in making this happen. So affidavit of probable cause for arrest warrant. The undersigned of the lawful age, being first duly sworn upon oath, disposes and states as follows. I am Special Agent Jason Ott of the Oklahoma State Bureau of Investigation. I've been a law enforcement officer in the state of Kansas and Oklahoma for approximately 27 years and served in the capacity of an investigator for over 20 years. I have read and prepared certain official investigative reports and statements of witnesses regarding the above-named defendant, and from these statements and reports, it appears as follows. On Saturday, March 30th, 2024, the Texas County Sheriff's Office requested Oklahoma State Bureau of Investigation, OSBI, investigative services with a suspicious disappearance of Veronica Butler, 27, and Jilian Kelly, 39, from rural Texas County after their vehicle was found abandoned near Highway 95 and Road L, south of Elkhart, Kansas. Butler and Kelly were traveling to Oklahoma from Hugoton, Kansas. Interviews were conducted and related to their disappearance. Interviews were conducted related to their disappearance, and it was discovered that Butler was in a problematic custody battle with Tiffany Adams for the custody of Butler's 2 children. The father of those children was Wrangler Rickman, Adams' son. Butler's visitation with her children was court ordered to be supervised every Saturday. Adams had a particular person she preferred to supervise those visitations, and that was Cheryl Brune. The court ordered Adams to pay Brune to supervise visits if that's who she wanted to be present. Otherwise, Butler was to choose and pay for the person to supervise. Adams said Brune was unavailable to supervise the visitation on March 30th, 2024, so Butler was required to arrange the supervision with one of her 3 approved individuals. Butler contacted Kelly of Hugoton, Kansas, and planned to have her supervise the visit. Butler told family members she was going to pick up her children from Adams and I'm going to take the 1000 hours to the regular time, 10 o'clock at Four Corners, which is the intersection of Highway 95 and US 64 West. It's a location in Texas County, Oklahoma. Butler and Kelly left Hugoton, Kansas, and traveled to Highway 95 and Road L, about 5 miles north of Four Corners. Butler and Kelly arrived at that location at approximately 9:40 in the morning. Butler planned to bring her daughter to a birthday party, but after they did not arrive, the family began looking for Butler. Melissa and Joey Padilla, who were Butler's family members, located Butler's abandoned vehicle just west of the intersection of Highway 95 and Road L. The Padillas then contacted law enforcement at 12:09 p.m. An examination of the vehicle and area surrounding the vehicle found evidence of a severe injury. Blood was found on the roadway and edge of the roadway. Butler's glasses were also found on the roadway south of the vehicle near a broken hammer. A pistol magazine was found inside Kelly's purse at the scene, but no pistol was found. Adams told OSBI that on Friday night, March 29, 2024, Rickman and Butler's children stayed the night with Barrett and Lacey Cook. Adams said she planned to pick them up that morning before visitation. Adams said she called Butler at 9 o'clock in the morning to confirm the meeting, and Butler told Adams something came up and she was not going to make it. Butler's phone records confirmed the call occurred. However, at the time of the call, Butler was in Hugoton, Kansas, in the process of picking up Kelly to go meet Adams. Adams stated she was home at the time that Butler and Kelly went missing. Adams picked up the children before noon from Cook's residence. OSBI interviewed Brune, and she said she was available to supervise the visit that day, but Adams told her to take a couple of weeks off from the visitation so Adams could question the children related to how Butler's approved visitation supervisors were. Butler and Kelly's phone records indicated their devices were actively sending signals to their carriers until approximately 9:42 in the morning, after which the devices were no longer seen by the networks and stopped transmitting. Neither phone was found at the scene or with the vehicle, and they are currently missing. Adams was the last known person to communicate with Butler and was scheduled to meet Butler and Kelly for visitation at 10 o'clock in the morning on March 30th, 2024. Through the child custody case, recordings were obtained where Rickman discussed death threats by Adams and Adams's boyfriend, Tad Cullum. The custody battle began in February of 2019 with many hearings and court appearances. On March 18, 2024 and March 20, 2024, motions were filed requesting extended visitation for Butler. A hearing was scheduled to occur on April 17, 2024. Butler's attorney informed OSBI that Butler was likely to receive unsupervised visitation with her children at that hearing. At times, Adams refused to let Rickman have his children, even though Rickman had legal custody of them. Law enforcement previously responded to a call for service where Adams refused to give Rickman his children. Reportedly, the officer told Rickman he believed the children were better off in Adams's care. Rickman's grandmother, Debbie Knox Davis, reported that in mid to late February 2024, Rickman told her they didn't have to worry about the custody battle much longer because Adams had it under control, that Adams knew the path the judge walked to work, and we will take out Veronica at drop-off. Rickman was confirmed to be in rehabilitation facility in Oklahoma City, Oklahoma at the time of the disappearance. The children remained in custody of Adams. Rickman denied having that conversation with Knox. On April 1, 2024, OSBI agents obtained a search warrant for Adams' cellular phone. OSBI agents performed an extraction on the device. Information gained from the device included web searches for taser pain level, gun shops, prepaid cellular phones, and how to get somebody out of their house. On April 3, 2024, OSBI interviewed CW, age 16 years. CW is the daughter of Cora Twombly and Kobe White. Cora is married to Cole Twombly. CW stated that she had overheard group conversations related to Butler not protecting her children from her brother, all in reference to a sexual abuse allegation. CW advised that she was told by Cora that Adams, Cullum, Cora, Cole, and Paul Grice were involved in the deaths of Butler and Kelly. She stated that Adams had provided burner phones to use so they could communicate without using their personal devices. CW saw 2 burner phones charging on Cora's nightstand in her bedroom. CW described Cora, Cole, Adams, Cullum, Paul Grice as being part of an anti-government group that had a religious affiliation. Through OSBI investigation, it was learned that they called the group God's Misfits. Regular meetings are held weekly at Twombly's home and at the home of Barrett and Lacey Cook. CW was told on March 29, 2024 that Cora and Cole would not be home in the morning when she woke and were going to be on a mission. When CW awoke approximately 10 o'clock in the morning, Cora and Cole were not home but came home around noon. CW knew that Cole and Cora took a blue and gray Chevrolet pickup owned by them and a blue flatbed pickup owned by Clint Twombly. When they left and returned in the same vehicle, they returned in the same vehicles. CW was told to clean the interior of the Chevrolet pickup. CW asked Cora what had happened and was told that things did not go as planned, but they would not have to worry about her, meaning Butler, again. CW was told that Cora and Cole blocked the road to stop Butler and Kelly and divert them to where Adams, Cullum, and Grice were. CW asked about Kelly and why she had to die, and was told by Cora that she wasn't innocent either, as she had supported Butler. CW asked Cora if their bodies were put in a well, and Cora replied something like that. CW also disclosed that other attempts to kill Butler occurred during February of 2024 near Hugoton, Kansas, in which Adams, Cullum, Cole, Cora, and Grice went to Hugoton, but Butler did not leave her residence. This is consistent with the web search discovered on Adams' phone about how to get someone out of their house. According to Cora, the plan was to throw an anvil through Butler's windshield while driving, making it look like an accident because anvils regularly fall off of work vehicles. While in Carrick, Texas, interviewing CW and her brother, Cora and Cole arrived and tried to get access to CW and her brother. Cora was verbally aggressive and was very upset with your affiant that she was not granted access to CW and her brother. Cole exited the vehicle armed with a handgun and a holster on his belt. OSBI investigation showed that Adams searched for gun shops on her cellular phone. A search of local gun shops showed Adams buying 5 stun guns at the Big R store in Guyman, Oklahoma. The purchase was made on March 23, 2024. OSBI investigation showed that Adam purchased 3 prepaid cellular phones from Walmart in Guyman, Oklahoma on February 13, 2024. The phone numbers were identified, but the phones were identified by the following phone numbers, and those have been redacted. Search warrants for the information related to location services and phone usage were completed for each device. It was learned that all 3 phones were at the area where Butler's car was located and the last known location of Butler and Kelly at the time of their disappearance. All 3 phones were powered on and accessed the cellular network for the first time at or near Cullum's residence at different times prior to March 30th, 2024. On March 30th, 2024, those 2 phone numbers before Butler and Kelly's disappearance were at the Twombly's residence prior to going over to or near Cullum's residence. Butler and Kelly's disappearance at 10:05 and 10:16 hours. Phone numbers 1 and 2 were in the area at or near Cullum's residence. After Butler and Kelly's disappearance on March 30th, 2024, between 10:16 and 10:35, it was determined that these phone numbers were at a property owned by Jamie Beasley, below a dam in a pasture where fresh dirt work was located by Urifiant. Concrete was moved from a location near Beasley's residence, approximately 150 to 200 yards below the dam, where it was discovered that a hole had been dug and filled back in and then covered with hay. The location where Butler and Kelly disappeared from and where Butler's vehicle was located is approximately 8.5 miles away from the location below the dam on Beasley's property, giving drive time from the location of where Butler's vehicle was located to Beasley's property well within 34 minutes between the time of Butler Kelly's phone stopping transmission and the prepaid phone numbers arriving at the dam on Beasley's property. All prepaid phones stopped transmitting on the morning of March 30th, 2024 at locations near Twombly's residence and Beasley's property. Beasley advised that the dirt work was done with a skid steer by Cullum on March 29th, 2024, and possibly finished on March 30th, 2024 in the morning hours. Beasley knew that Cullum left his skid steer on his property the night of March 29, 2024, and when he awoke on March 30, 2024 at approximately noon, the skid steer was gone. Cullum rents the pasture property owned by Beasley for grazing cattle and has access to it at any time. On March 28 or 29, 2024, Cullum asked Beasley if he could cut a tree down, remove a stump, bury some concrete, do dirt work where the concrete pile was and below the dam. Adams was with Cullum at Beasley's property when that conversation was had. In a contact with Cullum, Urifiant learned from Cullum that Adams is his significant other. Beasley agreed to allow Cullum to do the work. Cullum brought up the idea of doing the work to Beasley. On Sunday, March 31, 2024, in the morning hours, Cullum was at Beasley's house and told Beasley that people were looking for him for the disappearance of Butler and Kelly. Cullum told Beasley that he didn't want the police or people to cause problems for Beasley and said that all the skid steer tracks on his property without a skid steer looked bad. Beasley said that if anyone asked, he would tell them that Cullum had done tree work and dirt work for him. So that is wherefore the affiant prays this court to issue a warrant for the arrest of the within named affiant. So that some of your theories may be on track and some of them may not be. It is crazy. It is it's heartbreaking to understand how minors were pulled into this mess. It's you can't say any better than the number of people who've said it. It's hard to wrap your brain around this. It is so hard to wrap your brain around something like this.
It really is. And yes, and because Wrangler's mom had money and her boyfriend has money, they were able to afford good, and definitely were trying to fight her for a long time.
Mm-hmm. Oh yeah. So it's it's I don't know. It is just, what do you do with that kind of information? Quite honestly, what do you do with it? How do you don't make sense of it? You can't justify it. You try to explain it the best you can, and there's a lot of explanation right there for us all. Unbelievable.
Yeah. Traveling Teresa, that's kind of something Tara's kind of thrown around. I'm not sure. I mean, would they have put his name in the documents if he's an informant? I don't
We
know that answer, but maybe somebody in the chat does. But the thing with Wrangler's grandmother, I actually spoke with her on the phone earlier, and she's like, it's just making it completely not the way it happened. Like, it's making it sound like she knew that this was going to happen and she never said anything. And that's not how it went at all. And she was very, very, very upset. She said that she was told that they wouldn't even put her name in there. and then they put her name out there. So I told her, call the DA and see what she could do about it. And I'm not sure if
Yeah. Well, and I think if you you
she was able to
when I
speak with
first
anybody or
read
not,
it,
but, she's been threatened multiple times.
yeah, when I read the document, I didn't read it that way at first until it was kind of pointed out to me. I thought, oh, okay, because it sounded like, um, yeah, because to my understanding, I think there was a good relationship between um, the Wrangler's grandmother and Veronica, because she'd gone to this is the same grandmother that had been supporting her through the legal system to get custody of the kids back, and so um, I believe there's communication between there, and I knew Veronica felt her life was threatened, so I didn't for a second think that there was any kind of involvement on the grandmother side of when it comes to Wrangler's grandmother. Um, yeah, it's
No, she's
too bad that
absolutely tore
CW
up
didn't have
over
some.
this whole entire
Oh
situation.
yeah.
Um, when I talked with her earlier, Wrangler's father was actually there too, and I was able to talk with him a little bit for the first time, but, I mean, they're both just absolutely tore up over all this. She loves her grandchildren, and
Hmm.
she told me there for a few years, she was helping raise those children, and she hasn't been able to see them. Another thing, and I know she wouldn't mind me saying this, and the reason I'm going to say it is because it is being said that the children are with Veronica's father in West Virginia. I don't want anybody figuring out, because I know how social media crazy stuff can be, figuring out where he is and trying to track him down and track these kids down. Okay. So she told me
Hmm.
that she actually was told today, by a very, very, very valid source, that they are actually in DCF custody right now. So I did want to clear that up because I just know how crazy people can
Hmm.
get.
Yeah. Um, you wonder what the
You
God's
wonder
Misfits
what the
group
God's
must
Misfits
think.
group people must think of Cole. Cole's not the preacher. So Barrett Barrett is the preacher, but him and Cole kind of were, I guess, the way I understood it, kind of like taking turns with it at this
Yeah, there's
point.
like a dual leadership
But we're
thing
gonna
there.
get a whole
Yeah.
lot more into that very, very soon. Yes, so we definitely want to explain that whole situation and what's out there, because it's way more than like that you guys even realize now. And when I first heard about that, I thought like, well, first I was deleting everything off the group because I'm like, y'all are crazy. There's no way. And then when I got out there on the ground, I was like, oh my gosh. Because then I started hearing all stories and, everything that was
Mhm.
going on. We won't stay much longer, but I want to share, and you can talk, Tara. I just wanted to share a couple of the videos that I had taken while I was out there. So, because I haven't been able to share any of this stuff.
But it's gone so fast.
Give me just a moment. Let me get that.
That's how
Give me
they
just a
that's how it
moment.
starts. They build this religious community in certain nationalist themes. Next thing you know, um, it's them against the world. It certainly seems that way. Is the former Sheriff KM part of that group? There's a whole other
All
discussion
right.
around that.
This right here is at this scene. That is indeed an officer with a metal detector the day of the crime. So right there. So those that were saying they did not have a metal detector, there's video right there of it. Which is obviously, would they find a cartridge? Is that what it was, Tara?
Um, I, that was my source. Is a cartridge of sorts. Yes, that information hasn't been released yet officially, so I'm going to be hesitant to say what they found for sure.
Uh, Okay, I thought there was like something in the I thought there was something in the probable cause that said something about that. I know Jillian carried a gun. The gun was not found, right? But they found
The gun
something
was not
else
found, but
there with
the empty mag was. Yeah, the mag was
I thought
there,
that's what
or the clip. Yeah, that was there, but the gun was not.
the
Um,
empty mag.
and
Okay,
so, yeah,
got it.
I don't think that was the actual terminology, but there was. the clip or the magazine was there, and I'm sure people in the comments will definitely correct me because they were definitely paying attention. Um, but the pistol was not there, and I've seen posts from Jillian's grandmother or Jillian's mother that she did carry. So it's presumed that she was carrying that day. Um,
Yes.
yeah, I'm going through the comments, and Cole and Barrett are best friends. Cole was at Barrett's
And it
every
was, I
day.
believe, I just tried to text to get verification. The people or the lady that found the car was, I believe, Veronica's aunt or cousin. Don't quote me. It's one of the two, though. That is who actually found the car without anybody there, and
Yeah.
then called the sheriff. So I never could figure out why the
Mhm.
sheriff or the OSBI was saying the sheriff discovered it, because that was just kind
Yeah,
of
because I didn't align
strange.
with what I
And
knew
you can keep
too.
talking. I'm just
Yeah.
gonna show these other
Um,
videos. This next one is just
you're good.
yeah, the next, video I have real quick is just when everybody was saying, "Check the pig farms, check the pig farms." So, obviously, we went and this is what their pig farms are. A lot of you have already seen this video from when we were doing the lives out there, but they are all these pigs are all in here, they're on concrete. Those are their, their grain bins. They're fed just grain, and that's it.
Mhm.
So, um, it's a pretty well-run organization. So that was one. This one is Four Corners, where they actually were supposed to meet. And can you is that look like a empty building on the screen?
I'm not seeing anything on my end, but that's not unusual, um, for me to not see it. I'm not seeing on either one of my screens, so we may have to but I know there's a comment in there that says the audio is going in and out. I know my audio seems to be
Okay, let me
I don't
do
know if I'm
this.
lagging or audio, but I've got a
Okay.
heck of a windstorm up here too.
Okay. So this is it then.
Okay, there we go. So that's Four Corners. So this was the original meetup point. This was the the court approved meetup point. This is where it's located at Highway 412 and 64, 69. I can't remember the exact number. This is where Veronica was supposed to meet Tiffany to exchange the children, and they did not make it there. That's approximately 3 miles from where the car was found. I think either my audio is down or Carrie's. Can you guys? It's showing. Yeah, I just saw it too. Carrie, are you on mute?
I'm not sure if I am or not.
Oh, there you go. There you are. Now we hear you. Yeah, the audio is coming in and out, starting to get kind of laggy and a little bit of a pain. Um, so, and where are we? Where are we at now, Carrie?
So
I
this
wasn't
is
paying
like why I
attention.
said this area for the most part would have been fairly safe, but I can understand with what was going on why Veronica wanted to move to Elkhart. Elkhart, that
Hmm.
county has a very good sheriff's department, and she would have been well protected Elkhart for sure. But this is right on the highway. It does have traffic, but as does the place that the car was found. That also has quite a bit of traffic, especially on a Saturday morning.
Yeah.
So that was that, and I think that might be all of those.
I don't know if Grace is. I don't know if I'm saying that
And
correctly.
then
If I'm
this is
not,
just
folks, if I miss say something, just correct me. I'm guessing here. I've gotten in trouble once for mispronouncing something and assuming something. So, but I don't know if Grace would self harm, and I don't know why the his arrest wasn't mentioned as something of interest to in the during the press conference today. It's a fun question to go explore, I would guess.
yeah, that's really
How about the
interesting.
informant angle?
We're gonna be
Mm-hmm.
exploring that for sure. And
Oh yes.
and then one last video I have is of at the actual spot where the car was found. So I do have that. Let me get that up here. Oops. Now, this is about 2.5 long videos. Give me just a moment, and then I'll mute myself out.
Okay. Is Beasley cooperating with police? How did he not see this take place on his own property? Nothing on Beasley just yet, other than being listed in the affidavit as it was the property where it was found, and initially would say that Tad was just doing work out there. So there's more to come on that one, I'm absolutely certain. Cora said it didn't go as planned, makes you wonder what the plan was. Yeah, I have my wonders too. So there is where that's where the car was found. You can take a look there. It was really windy out there those few days. If you were watching those live streams, it was so windy. Yes, according to the affidavit, the property is 8.5 miles from yes, that is correct. So from the site where the car was found to where the location that was described in the affidavit, it was 8.5 miles difference. Let me see what else is in the comments. But Tad asked him to lie, and yeah, Tad did ask him.
So all that,
Well,
you can
Tad,
see all of
yeah,
that
according to,
grass.
yeah.
This spot right here is where we believe the blood was. That's the kitty litter on the ground over the blood.
Okay. I think you're right, Bethany. I don't think they were.
And those were.
Oh, sorry. Go ahead.
Also holes dug up by law enforcement. Oh, I just said those little holes right there.
Yeah.
That's what was
Yes.
dug from law enforcement. I'm assuming like more blood evidence and stuff.
Yeah, I imagine you're right. Absolutely. There was a comment that Tiffany and company didn't probably think to realize that somebody would be carrying a weapon, and I would imagine that's true. If I had to speculate, and I kind of will now since we have some information out there, I think things didn't go as planned because I don't think that they expected two women to fight for their lives. I think they thought they would just ambush them, take control, do whatever they planned to do, but these women fought back. And so I do think it was not very well planned, clearly. Not in my opinion, anyway. So, yeah, I think, so to say that too, if you say it didn't go as planned, you have to kind of wonder, was the car meant to be found? Or did they run out of time? Did things not go as planned? How much that impact their plans? There's a lot of questions to answer there. Scott, was I following true crime before you met Carrie?
Yes,
no.
Definitely.
Carrie and I met by happenstance. I found her Facebook group. It aligned with the kind of discussion group I wanted to engage with. And I couldn't sleep one night. The case kept me up. That's not like me to lose sleep over something. So I messaged Carrie to basically qualify the group, asking her, are you actually investigating? Or are you just leading a discussion group? And she responded, which really shocked me. And she said, no, I'm investigating. I'm going out there. I'm going to go look. And I was like, you know what? You need some help, you let me know. And we have been kind of attached at the virtual hip since then. So now I follow Carrie. Now I'm a subscriber and a member and all that great fun jazz.
Yes, Tara's been amazing. This video here is the day that the car was found. So this is that day.
It's very surreal. Oh yeah, Margaret, I'm sure they took soil samples and all kinds of stuff.
There was a lot of law enforcement there.
Yeah.
Mm-hmm.
Yeah, there is a lot going on.
So
this Carrie movie have you hooked? Yes, Scott, she has me hooked.
I have a whole lot more to show you guys, but we've already gone for 2 hours.
Yes. But it's been a very good 2 hours. Yeah. She's stuck with me now.
Scott's
I
the
think
one that got me a YouTube channel off the ground.
Oh.
To be very honest.
No wonder he's asking me. Yeah, so I wasn't a follower. I didn't know about Carrie.
He shared my first video when I was live, and
No, it's been a great ride with her though, and we're not done.
Yeah,
We're both
he
in
was
it.
already in the summer Wells community, I came in and I yes,
Oh,
thank you. Absolutely.
yeah,
Yeah, that was a lot of law enforcement.
we've got a bit of a lag and cutting in
So,
and out on our
we still have
audio.
so much more to share.
Oh my god, yes.
There is a little bit of a lag. Let me move this
Mhm.
out. Let's see, kick from studio. Oh, I think I just kicked Tara. I didn't mean to kick you, Tara. Let me drop the link for you real quick. Sorry about that. Oops. Thank you so much, Britt. Thank you for modding as well, to the mod in here. Thank you very much. So far it's gone really, really well. I don't, a lot of times I can't see all the comments because if I'm reading, of course, but we just really have had a lot of good people in the chat, very respectful, and I can't tell you how much I appreciate that because, I am in contact in our group. They do watch the lives, and we have to be honest about the case, and we want to present it to you factually, but at the same time, a lot of things that we discuss, are hurtful for things factually. So, you know, it sometimes that hurts, and I apologize for that because that's not our intention at all. What we want is justice, and the only way to get complete justice for all of this, I'm talking about they're dismantling that organization they have and more. The only way to get that justice is by speaking the truth. So that's just what we're doing.
Mhm. Yep, agreed.
Photos, a ton of video. When I was out there for 6 full days, and I only went live the night before I left, just as a kinda explain the community and how it was for me being there on the ground, and things like that. So, I went live that one night, but that's it. I didn't do any of the other, but I certainly have tons of video and photos. It'd be great to do a live where we just share all of that kind of stuff that I do have and do all in, or maybe let some people up on panel, let them ask questions. If
Mhm.
family want to speak, they can, friends. But yeah, I think that, we're kind of at the point now that now we've been able to present all that information that we couldn't previously, or, we didn't have time really because everything just kind of happened so fast. But it would be great to do just an easy going live like that, I think, for the next one. And then we are going to be working very hard on that um, organization out there to present all of that information for you.
Yep, agreed.
So
And
the
do I
court
live in the
hearing,
community? Oh,
I
go
live
ahead.
about 4.5 hours, about 4.5 hours from there. It's okay. I live about 4.5 hours from there, and it's going to be a bond hearing. So when those go, I'm hoping somebody that is in our group. I mean, no doubt somebody will actually go to that for us. I don't know if the media will live stream it. I don't know what the court's rules are going to be for that. That's something that they're going to have to think about quickly, because I'm sure the media is going to want to be there. And if they stream it, we absolutely will. And if the media does not stream it, we will have somebody on the ground that can, give us all that information pretty quickly. What were you going to say, Tara?
I'm in a terrible lag, so I was trying to remain quiet. There was a message or a question as to whether or not I lived in the area. I don't. I'm about 5 hours away from the Texas Cimarron counties. I live in Kansas.
So Canon Art said the court made a statement today, no pics or videos or audio. Court clerk confirmed this. That doesn't surprise me one bit at all. So hopefully we can get somebody, that'll go in the courtroom for us. But if not, there'll be, plenty of news organizations that'll report that back. And we will definitely let you know what that is. Yeah, that was so sad about the daughter. So sad. There's one other thing I can share with you guys real fast, and then we're gonna wrap it up. Okay, give me a moment. So this is just, this is where the bodies were recovered. As you can see, Boise City is right here. You hear that name a lot. You'll hear Keys, because that's where they lived. Grandma lived. Griggs is a location of where they have their meetings and the old school. Well, I was trying to get closer here. Look, I'm not Gray Hughes yet. Okay, but there we go. So, over here, I believe it was right in this area because, or well, it had to have been pretty close to this area right here, because the man that, had the property or the property next door was taking pictures and video, and he had said that Tad had leased the other property. So, but that's where they were. And it's just nothing but land everywhere.
Yeah.
I mean, as you can see. So, anyway, all right. That is all we have for you guys tonight. Hopefully, it was informative and we all learned a little bit together. And let's do this again and just maybe just make it relaxed and kick back and ask questions and answer those. What do you think, Tara?
Oh, yes, I think so, and I think it'd be a good time too. Absolutely.
Yeah, about whether or not this might not be the first. I mean, there are other people that have had things happen to them out there that have gone unsolved. So that part is true. Is it like a ton of people? Like, there was some rumor of that in the beginning. It's not a ton of people, but I definitely, we talked to a person who had two members of his family, and those were unsolved right there in that area. There's also a female, so there are a few for us to at least look into. But to me, I mean, it's just my opinion. Uh, they sure pulled this off. I mean, you got four people. Well, it was more than four people, but to have all these people to agree to something like this, it just makes you wonder, like, is this the first time?
Mhm.
This is so easy for you to do. I don't know. That's just my thoughts. I can't say for sure or not. So Barrett was best friends with Cole and Lacey was best friends with Lacey. They openly spoke of the heinous acts around a 16-year-old. I'm positive Lacey knew. I agree. I agree. And that's why I said we're going to have a lot more to come on that. And it'll take us a couple days to put that together. But maybe, before we do that, we'll just do it. Just a question and answer kind of thing. If people want to come on panel or call in or whatever, we'll do that too. So, all right. Well, again, thank you so much, the mods. I appreciate you. We always appreciate Tara. She adds so much to all of this for us. And we appreciate everybody in the group that's shared information, shared tips, and helped to get where it is now. And I really appreciate you guys being here. So with that, we're going to log off for the night, and you guys have a great evening. If you haven't yet, please do like the video, and I'd love to have you as a new subscriber if you're not one already. All right. Thanks again, Tara.
Thank you. Hopefully you can hear that.
I did. All right. Bye-bye, guys. Thank you so much.
Bye.